welcome to one more episode of Lexpeeps interview series. Today we have our esteemed guest, Advocate Anand Mishra. Advocate Anand Mishra, sir, is an advocate on record at Supreme Court of India. He is a member of SCBA, member of Supreme Court Advocate on Record Association, advocate on roles of Bar Council of Delhi. He deals in civil, criminal, corporate, consultancy, ADR, and other legal auditing issues. Sir is also proprietor of Devdutt Consultants. So today we will have an interview session with him. I will be shooting questions in next some minutes and he will be answering that. I welcome you, sir.
Thank you so much.
Should we start with the questions?
Sure, you can start.
Yes, sir. So the first question is, sir, you have a vast experience in the field of litigation. How would you describe your journey as a lawyer?
So I did my LLB from Campus Law Center in Delhi University, and I passed out in the year 2006. If I just look at the background and regarding my past, the journey was almost clear to me from the first year of my LLB because I had decided to move into litigation from the day I joined the LLB, because that was the only option in the legal field which I had looked for. So in 2006, when I did my LLB, I joined a chamber, and I had a vast exposure dealing with district courts, high courts, various tribunals, as well as the Supreme Court. Thereafter, in 2009, I became independent. The journey has been a smooth journey, as this is a noble profession and gives space to every budding personal. One thing I have just found, that initially I thought that it is a marathon when I was in the juniorship, that we have to be slowly and steady moving. But I have just found in the area of independent practice that it's a sprint running one after the other. So every day you are into a sprint race, and the journey has been a wonderful journey, I can say.
So, very beautifully described, sir. So the next question is, as you are an advocate on record and many students aim to clear the examination of advocate on record, how difficult it is to clear the exam?
Firstly, I may say to you all that there is no examination to be called a difficult or an easy examination. Every examination moves towards the discovery of knowing certain patterns. The same is with the advocate on record examination conducted by the Honorable Supreme Court to find the competencies of the persons who are filing the cases before them. The main pattern is that you should be very well aware with the Supreme Court rules and with the drafting procedure of the Supreme Court. So once the 4-year period is there plus 1 year training under AOR, if from the first year itself you are in the drafting, you are going through the Supreme Court rules, you are attending the courts, you are curing the defects, you are even numbering the files. So I think that 60-65% of the knowledge you gain by experience. And once you understand that what they are looking for, that you are very much good in drafting, you should know how the petitions are drafted in Supreme Court, what are the defects which are raised, what is the Supreme Court rules, plus how to do case researches on the latest cases before the Supreme Court, as well as the duty, the powers of the constitutional courts in India. If you are aware with that thing and you understand the pattern that what the examiner is looking for, you can clear the examination.
So what impact it adds to the career when you are an advocate on record?
As far as the impact is concerned, if you have decided to practice before the Honorable Supreme Court, I think that the advocate on record examination gives you a certain, that you are able to file the thing. You can file your own wakalatnama, you can appear before the court on your own. That is an added advantage, that you are not dependent on another advocate on record. That is the thing I can say, that you become a part of a system to some extent, I can say. But there are other people who are good arguing lawyers and they have not been advocate on record. It depends. But I decided to be the part of the article record system to file my own cases, which I have drafted in my own name. That is the thing. That is a small leverage it might come.
Yes, sir. That's great, sir. Sir, the next question is, it's not actually a question. It's what has been the most memorable case you have handled so far?
There are many cases, and I may say one thing to you all that every case is a memorable case. One quotation I want to say as a respect to my senior who helped me a lot in this profession. When he handed me the first brief, I just told that, sir, I'll lose the case. So he told me that, Anand, you never lose the case, you never win the case. The cases are only disposed of in the interest of justice. Our duty is only to assist the court in the best possible manner. We are not going there to win and lose. We are going to assist the court. But as far as the memorable cases are concerned, first is a very, I will say, when I became independent, as a mark of respect to that brief which I got on the second day of becoming independent, it was under 138 Negotiable Instrument Act. We were a district court, and somehow there was acquittal in this case in favor of my client. But two more cases before the Supreme Court. One is a case of Satvinder Singh. He was a person who had schizophrenia after 18 months of deployment at the border area in the Indian Defense Forces. And he was thereafter, his disease was, he was downgraded in the medical category, and thereafter he was discharged from the defense service. And the tribunal, as well as initially it was before the High Court, but the tribunal didn't interfere, and we went to the Supreme Court. And Supreme Court really held that this is a thing which is aggravated because on the board of entry when he was recruited, he was not having any disease, and if he got schizophrenia, just 18 months of border posting, it is a thing which is aggravated by the military service, and so is entitled to the disability pension. That is the first case. Second case, there was a matter from Maharashtra in which what happened that a young man has died in an accident, and the Honorable High Court has applied the multiplier of the parents of the deceased, saying that the parents are too old and now we can apply the multiplier. And we came before the Supreme Court, and the Supreme Court, again, in terms of its earlier reportable judgment, again held that it is the age of the deceased which has to be looked into for applying the multiplier. So these are the 2-3 cases I can say that are memorable. Otherwise, every case is a memorable case for me, because my aim is only to assist the court in the best possible manner I can.
Yeah, this is the best tip a young litigator can get from an experienced person like you.
No, I cannot say that I'm experienced. There are many much more experienced person in my profession, and I'm just I'm also a learner in this profession as on date also. I cannot call myself to be elder in this profession. This bar has a very great tradition, and I'm just a very small, I can say a small person in that great tradition.
A really kind word, sir. So another question is, the students of the law school are quite inclined towards getting good grades in school. Do grades have any significant impact on career in long run?
Look, one thing I can say that obviously knowledge of law is important. Orator skill is important. Delivery is equally important, but you cannot, if you're going to assist the court, you should have the knowledge of the law. If I can say to all the young person, my friends in this profession, that when you look at a life, you're just climbing a mountain. And when you climb the mountain, you never look at the peak. You only look at the next step. So every person in this profession, all my young members, I will just say that you only look at your next step, keeping in mind your future aim. Your future aim is certainly whether in litigation or whatever field you want to go. But since you are going for examination and your next step is the grade, so you should focus. I'm not saying that you should be emotionally depressed if you're not getting a good grade, but you should work really hard, thinking that this is as important for the gaining of knowledge.
That's great, sir. So, in the wake of COVID-19, courts have started functioning virtually rather than traditionally. So, is this new concept of virtual court has uh, came up as a better alternative to the traditional court?
Firstly, let us be clear that we cannot compare the earlier times with this time. We should be having a great respect for the courts which decided to function in such limited of time through the technological virtual mode. And they are
Definitely,
really delivering. They are working very hard. The
definitely,
pandemic didn't lift any option to us. One thing I can tell you that the pandemic, any type of pandemic, it doesn't weakens the system. It exposes the already existing weaknesses of the system. But our system, even the Honorable Supreme Court, we have shown the resilience. We have been able to adapt in a limited period of time to a new mode. But we are saying that okay, less cases are getting listed. But what is the time? It just started in the March, not even 6 months, and the courts have adopted to the new technology. I think it's a good achievement of this new phase where even the persons in our profession have become more technologically friendly, and we are able to do many things where the geographical limitation has been removed. Now, suppose this interview is being conducted. I never even contemplated that anything will happen on a Zoom.
yes,
It is saving time. Our geographical boundaries have become less. And if you
definitely.
are having a competence, you can appear anywhere. The geographical barriers will not come in your way. So I will say that even in the pandemic, our legal system has shown its resilience, and we have adapted to change, and it is for a better future.
That's great to hear from you, sir. And so there are many graduates who passed out this year, or there are many people who are quite young in the profession. So how far do you see that COVID-19 has impacted the profession of young advocates or lawyers who has came into this profession?
To some extent, because our traditional mode of working got derailed, the chambers were sealed for a certain period of time. So it had impacted. But so the other professions have been impacted. If I can say one thing, in case you are not able to do geographical traveling, you can work through e-learning. These things, these moments, we should take as a challenge. How we should adapt ourselves, how we should adapt our professions to the new requirement. There has been an impact. I cannot say that there is no impact. There's impact on everyone. But remember one thing, either you lead the change or the change drags you.
Definitely.
So you have to be adaptable. That's a basic biological phenomena in any evolution process. It has impacted, but you cannot say that now the young professional should think that how we can work in this atmosphere.
Indeed.
What is the new technological systems as well as the emotional level as well as the working patterns which we should adopt so that we can prove our relevance at this moment of time also.
That's great, sir. Uh, so the next question is, what are the things that a litigator should avoid in initial days of practice?
One thing I can say as a litigator, as a litigation lawyer, there are three duties. First and foremost, officer of the court. Secondly, the duty towards our own fraternity, the bar. And thirdly, the duty towards the client. The first thing which any litigation lawyer should know from the first day, that his most pious duty, his foremost duty is to the court. We are not the spokesperson of the client. We are there to assist the court, telling him the facts of the case of the client, to give submission so that the court may arrive at a fair truth. So that is the first thing a litigation lawyer should know, that he should not travel beyond his scope. You are foremost the officer of the court. Your main duty is towards the court, but yes, you have a duty towards the client to represent his case. You have to maintain certain hierarchies. And one thing that this profession will give opportunity to every talent, I can say, because I am also a first generation lawyer. I am not from Delhi. It will give opportunity to everyone. In case you remain fair to this noble profession and you have the capacity to live like a hermit and work like a horse, then I can say that the sky is the limit.
That's truly
Because
inspiring.
once, if I just want to say one more word, because what happens when you are submitting before a court of law, you require a moral strength also. And in case you are fair, you are always with the truth, and you are never a spokesperson, your moral power increases. So you have to be always fair to the honorable court. That is my, I can say, one of the principles I kept in mind from the beginning, and I'm still maintaining it. I will maintain. Everyone is maintaining in this profession, I can say.
Yes, sir. That's truly inspiring and great to hear from you, sir. So the next question is revolving around the law school. It's the question is, do participation in extracurricular activities like moots, seminars, paper presentation, these things add something to the career, or do it have any significant impact in long run on career, or do it leave certain kind of impression on the recruiters?
Look, there are three things. First is the, I'll say, knowledge. Second is the talent. And third is the attitude. Knowledge you can take from anywhere, but the talent is something which comes to an individual centric body. And thereafter you go to the attitude. So these extracurricular activities, though by learning, by giving examination, you are having knowledge. But to develop certain talents, to develop an attitude, you you should participate in extracurricular activities. You should participate in the moot court. It makes you much more, I say, confident. It takes the orator skill and other things which are hidden in your personality out. And it's going to be helpful. I will not say whether it will be impressing a recruiter or not. That is the thing which is in the control of a different person. But one thing it's
Definitely,
going to do, it will be changing your attitude. And
definitely.
that's more important. That's more important.
That's great, sir. Uh, so, do you think there should be some certain kind of changes in the Indian legal education system?
Actually, the Bar Council is doing a fabulous thing in that. And I can't say that there should be, but one thing could be there in case if it is incorporated. Number one, that whenever the questions are set, I think I don't think whether it is being done right now. It may be have been started even, because I am way back in 2006. I don't know what's the curriculum going in 2020. But one thing that if in case you develop a drafting ability as well as writing your own submissions on certain facts, instead of going by a thing that you give an answer, a certain type of curiosity is developed where the student is able to draft the entire, I'll just say minimum drafting from the first semester. You cannot go through a drafting of the complete petition, but you can certainly develop certain ability of putting the facts into the ingredients required, as well as I will say, putting his submissions also on the paper, that wow, he thinks, how he wants to bind the various case laws and develop his own submission. That will be. And one thing this pandemic has also shown that our technological innovation should also be included. That how to work through the electronic modes. This pandemic has taught us a lesson that these things should be taught from the initial stages itself.
That's great to hear
Otherwise,
from
the
you,
Bar
sir.
Council of India is doing a fabulous thing. I don't think that any recommendations are required in that
Definitely, sir.
regard.
Uh, Sir, on a concluding note, what will be your message to the budding lawyers?
My message will be that you are joining not a ordinary profession. You are joining a noble profession, a profession which has a tradition, and you have to carry forward that tradition. The sole aim should not be money, should not be fame. These are all byproducts. They will come to you, but you should commit yourself towards the tradition of the bar. That is your primary duty, and then all things will fall.
That's great.
That's my only suggestion to them.
That's great, sir. Really kind and awesome words from you. Through this question, we came toward the end of the episode. And it was really awesome to talk to you and discussing all these points. I surely hope that this will help all the budding lawyers and who will be seeing this episode.
Thank you so much. Thank you so much.
I thank you from the core of my heart and on behalf of entire Lexpeeps team and on every budding lawyer who will be seeing this interview.
Thank you.
Thank you, sir.